I'm David Mark. I'm a senior editor at Politico here in Washington, D.C. Thank you so much for joining us on this temperate Washington evening. It is my pleasure to be here moderating this panel discussion hosted by the University of Pennsylvania Law School as part of its Penn Law Washington series. Penn Law has launched the series as a forum here in D.C. to discuss the great issues, legal issues, political, and other issues of our time. We're here as Congress is meeting, trying to hammer out an agreement on the super committee as the presidential race gets going in earnest, and as we tackle any number of other consequential issues that will be with us for years and decades to come. We're most fortunate tonight to have with us several experts who can shed light on these topics. We've been watching them all in the news, and it's my pleasure to be here with everybody. I'll start with Senator Arlen Specter, the longest-serving U.S. Senator in Pennsylvania's history, a Penn graduate. He's now teaching at Penn Law this semester as an adjunct professor of law on the topic with which he has some familiarity, the separation of powers. I could go on about his numerous accomplishments over the decades, including his service as Assistant District Attorney of Philadelphia, then as District Attorney, starting back with the Warren Commission before that, the books he's written, and many other accomplishments. During his tenure in the Senate, he served on the Judiciary Committee, I believe, throughout his tenure there, beginning in 1981, including a stint as chairman from 2005 to 2007. And he participated in the confirmation hearings of 14 U.S. Supreme Court nominees and recommended 112 Pennsylvanians who have served on the federal district court in Pennsylvania and surrounding states. His work on the Judiciary Committee included writing significant legislation dealing with constitutional law, civil rights, privacy, and numerous other issues. Joining me here on my left is the Honorable Gene Pratter, judge for the U.S. District Court for the Eastern District of Pennsylvania. After a long and distinguished career at the law firm of Duane Morris,
we might de-emphasize the long part.
an ongoing distinguished career. In 2003, President George W. Bush nominated her for the district court, and she was confirmed in 2004 unanimously by the U.S. Senate. During her time at Duane Morris, she was the firm's first general counsel from 1999 to 2004, and she also chaired the firm's ethics committee. Her other service includes serving as co-chair of the ABA Litigation Sections Committee on Ethics and Professionalism, and she also chaired the Professional Responsibility and Professional Guidance Committees of the Philadelphia Bar Association. In the interest of full and fair disclosure, she's also a graduate of Penn Law. And finally, here to my immediate right, we have Michael Fitz, Dean of Penn Law and the law school's Bernard G. Siegel Professor of Law. Before joining the Penn Law faculty, he served as a clerk to the Honorable A. Leon Higginbotham, Jr. of the U.S. Court of Appeals of the Third Circuit, and as an attorney advisor in the Office of Legal Counsel here in Washington in the Department of Justice, which serves essentially as the outside counsel to the White House. He has written on questions of administrative law, presidential power, and...
Not on terrorism, though.
Okay, we'll stay away from that one. Separation of powers. He's argued for improving the structure of political parties and executive branch decision-making. Mike is president of the American Law Deans Society and a member of the Law and Political Process Study Group of the American Political Science Association. So we may have crossed paths at some of their conventions from time to time. In his day job, he was recognized recently as one of the country's most transformative law deans over the past decade. And starting with his tenure in 2001, since his appointment, he has built cross-disciplinary programs at Penn Law that integrate not only traditional legal teaching and scholarship with related disciplines, political science and others, with the aim of preparing future lawyers to solve many of the problems that cut across these disciplines in society. And we'll get to those in just a moment. So please give a warm welcome to all our panelists here. And I just want to begin by talking about the political paralysis we face in Congress, the White House, not too far from here. We've got, with a Democratic president, a Republican House, a narrowly Democratic Senate. We're at a point where even the most basic government decisions are now drawn and protracted crises, whether it's just getting annual spending bills passed, raising the nation's debt ceiling, which is usually just a government bookkeeping maneuver, something with longer-term effects, the filling roles on the federal judiciary, other political appointments, the confirmation crisis. So I want to begin by asking Senator Specter and my co-panelists, is the state of political paralysis worse than in the past, or is it more a function of the kind of hyper-speed media age in which we live, in which everything that a member of Congress, of course the president and others say, is put on Twitter, replayed in the news cycle, and gets played up to dramatic effect in the way that perhaps it was not in the past?
It is worse than at any time during my tenure. I think that you have to go back a long time, perhaps to the Civil War, to find the contentiousness which is there at the present time. And there has been a determination from the beginning of the Obama administration to defeat him in 2012. The ink was not dry on the oath of office when Senator DeMint said that we would construct his Waterloo. And Senator McConnell has articulated the proposition that the legislative agenda of the Republican Senate caucus is to defeat Obama in 2012. And the procedural devices used to promote the gridlock are not the inventions of the Republicans. They were started long ago and have been practiced by both Democrats and Republicans, experts in gridlock. The Senate had been renowned at one point as the world's greatest deliberative body because any senator could offer an amendment on virtually any subject at any time. So the Senate was a great forum for new ideas, and that has been changed. Now amendments are not offered because people want to be safe. Just a brief comment on the debt ceiling issue. The super committee, which is now in existence, in my opinion, was calculated to fail from its inception. Its purpose was to give political cover on two big events. One was raising the debt ceiling by deferring any of the tough votes on what to do about taxes or what to do about entitlements. And the second was to put it past the 2012 election for the benefit of the president and for the benefit of anybody else who is running. The law can be changed, and now you see, as we grow closer to November 23rd, a lot of talk about, well, those automatic cuts are not going to happen. Not popularly understood that what Congress enacts, Congress can change. And we had the same kind of automatic cuts projected 25 years ago with Graham-Rudman, and when the tough times came, they were changed. So it's kicking the can down the road, avoiding any of those tough decisions, and gridlocking the process.
Dean Fitz?
I think the senator obviously correctly observes that we live in a very different political environment than we've seen before, that the parties are further apart than we've ever seen. We don't have the big tent political parties, that in a sense every Democrat is more liberal than every Republican, and every Republican is more conservative than every Democrat. And we live, as was pointed out before, in a media age. I do think it's important to understand that this is a political environment overlying a system of government that the framers intended to be in sort of a checks and balances. I mean, if you think about for those of you who took first-year constitutional law, that the framers believed in a certain degree of inaction. They believed that the branches would be divided, that we would have branches elected over different periods of time, different constituencies, and that before government acted, that there would have to be a certain degree of consensus. And if you step and look back over the last 3 years, a lot has happened. We passed healthcare reform, which had sat on the sidelines for 40 years, a major stimulus package, and financial reform. So it is a period in which there has been a lot of action from a long historical purpose, even though the acerbic quality of differences between the branches has sort of framed the fact of the divisions, and it made it a very unpleasant process. I think the question is going forward from here, whether in fact there will be compromises reached on issues such as entitlement, job creation, and taxes, and whether we're going to have to wait until the next election before, in effect, the American population makes choices between all of the different proposals that are being presented.
Judge Pratter?
Well, as the representative of the weakest branch, I would like to think I am not a weak sister by being here or being invited to be part of this. As you all know, I have certain constraints, as do all of my colleagues on the federal bench. It's probably the greatest part, one of the great parts of being a judge is that we can draw away from that kind of discussion when we wish. We also don't have to answer the phone when people call asking for money. It's fabulous during election season. Beyond that, though,
She doesn't answer my call.
well, that's a different kind of money. The fact of the matter is, though, that Dean Fitz talks about what the founders had intended. And it occurred to me, listening to what we talk about democracy and the vibrance of what goes on in election season, I invite those of you who don't go to court every day, come on down. If you want to see democracy in action, it's there at the grassroots level in the federal trial courts. And my colleagues and I are practicing the politics of democracy in terms of what real people, real cases what they present to us. We don't go looking for the issues. They come to us. And so our politics, if you will, and our election year is every day because we issue decisions. People, half the people like them, half the people don't. It's part of the job. It comes with the territory. So in some respects, while the season and the reckless rhetoric does resonate with me because the courts have been the object of some unusually strident talk recently, and it doesn't go unnoticed. But in terms of the workaday world that I'm in, my work is unaffected by it, although we have been the subject of a lot of unusual, puzzling talk recently.
Thank you. Just sticking on the issue of bipartisanship a bit, there's a long, lamentable history of looking back to the old days of that notion that Senator Specter was talking about of bipartisanship working across the aisle. But can bipartisanship be a negative in some cases? Can it deny voters a real choice between differing, competing viewpoints of government? And does it even foster collusion in some cases of both sides working together, not necessarily for the public good?
Well, you seem to be calling on me, or at least looking at me, so I will respond. It is interesting. For those of you who are not lawyers but were undergraduates in political science, You may hearken back to your first year college political science courses, where most people who were schooled in that tradition argued for, in some sense, exactly what we have. Parties who had clear ideas, articulated clear standards, not a real choice between the two parties in government. And in the 50s, there was charges that, in fact, the parties looked like Tweedledee and Tweedledum. Well, of course, be careful what you wish for. They don't look like Tweedledee and Tweedledum anymore. You have clear articulation of views. I think the advantage of that is you hear now on a public level about as fundamental a debate of the role of government and the purposes of government that I can recall. So that both the checks and balances of branches and the divisions of the party has created a dialogue. Now, the problem is a dialogue on a 24-hour news cycle with so much at stake, with so many issues, causes serious problems. If we'd gone back to the 50s and 60s, obviously the parties would have been able to maintain and work with this and probably reach compromises much more easily.
I don't think bipartisanship, I have to say, could ever be bad. Ever is a long time. But I think this republic was founded on compromise. The first big controversy they had was, how are you going to have representation in Congress? Small states, big states. And 2 houses were created so that Delaware has as many senators as California. And, the House has population. And you have now candidates in the Tea Party running on a platform of no compromise. No compromise. The whole essence of government is an accommodation of different points of view. And if you have a strong view and it is articulated, you can get it passed. But there's nothing wrong with having the other side participate. And I think the public is comforted and assured if there is bipartisanship. Public can't follow the nuances of all these issues. Dean Fitz talks about 3 items which were passed. Well, that's a puny result. And it couldn't happen again. Those 3 things that were passed were the health care bill, because there were 60 Democrats in the United States Senate that were nowhere near that, and that's what it takes. And then the gyrations were phenomenal. Cloture votes at 1 a.m. week after week to run out the clock on the delays. And you had reform to an extent of Wall Street. I don't think it's happened at all. The regulations still haven't come out. But things were so bad, they blew up the country with the toxic mortgages. Who couldn't say that there had to be some reform of Wall Street? Impossible not to say that. And the stimulus was passed in a context where 3 foolish Republicans joined to break the filibuster. And now one of the Republicans is unemployed, has lots of time for evening panels, and the other 2 Republicans are running for their lives. We had last year, we'll get to Citizens United because we always do, and I'll try to be brief in closing here for this presentation. You had the Supreme Court leave open 8-1 that if corporations could run the political campaign world, at least you'd have to disclose who they were. And 59 senators on one side of the aisle a year ago this time voted to advance that bill. And not one Republican would stand up notwithstanding the fact that Senator Snowe and Senator Collins were big exponents of campaign finance reform with McCain. And McCain was there, and Cochran, and many Republicans were on the record for disclosure. So my conclusion is there's not a Republican moderate in the Senate today. I hate to go right at you, Dean, with your 3 examples, but I don't think they prove a whole hell of a lot.
Well, stepping across the street a bit from the Capitol building over to the Supreme Court and the federal judiciary generally, we continue to hear this charge of judicial activism against decisions that people might not like for one reason or another. It seemed like that was more a province of the right until maybe 10, 15 years ago. Now both sides seem to go at it pretty aggressively in labeling decisions with which they agree judicial activism. Judge Pratter, I want to start with you by asking, is there such a thing as judicial activism, or is it judicial timidity? Should the courts play a more assertive role in the balance of power?
It's neither. Obviously, I think it's come around now that most people recognize the term judicial activist to mean somebody I don't agree with. I mean, I think that's fairly now the meaning of the term, so that it has been discredited as a meaningful term, except to say something more about the speaker than the object of the comment. Timid, I don't know. Timid, I think that there's perhaps the right word is to remember that what we do is preserve our independence by exercising judicial restraint. And that's perhaps the best way for the judiciary to maintain independence and to keep a good relationship with our friends and colleagues in the other branches by showing that we're minding our knitting, if I can use that phrase. And that is we stick to cases and controversies. We shouldn't go looking to decide things that are not before us. And I know I'm a student of Senator Specter's, and I recognize that he has a catalog of cases that he would take issue with, and well, he should. Everybody should take issue with some case, because that means people are reading what the judges have written. And so I applaud discussion about and disagreement with decisions, and not mine so much, but but all those other guys. But that doesn't mean that you attack then the structure of the judicial institution. So I think that we don't have activist judges. We don't have and shouldn't want timid judges. You want judges who are honest, who are willing to apply their intellect, and who are willing to decide cases that are presented to them. And that's how we do our job. And we have an outreach to the Congress, with whom I think the judiciary does have and wants to keep a good relationship for lots of reasons, not the least of which is that that's how we all serve the people the best way.
Senator Specter?
Judicial activism, let me count the ways. We'll reserve Citizens United again. Violence against women, federal legislation to protect women, massive record, 5-4 decision. Chief Justice Rehnquist says it is the congressional, quote, method of reasoning. There's a magical transformation, ladies and gentlemen. You may not have noticed it. When you leave the Senate hearing room, when you walk across the green to the Supreme Court columns, there's a special, Rehnquist said, judicial competence. Judges are supposed to let Congress find the facts. You have the Americans for Disability Act. You have the City of Borney case, 1997. The test for upholding legislation was always a rational basis. in Garrett versus Georgia and Lane versus Tennessee, 2 Americans for Disabilities Act, exactly the opposite result. Justice O'Connor could find congruency in one and proportionality, but not in the other. And in Citizens United, the Supreme Court didn't like the issues which were posed, so they structured the issue they wanted to decide. A highly unusual proceeding, not totally unprecedented, but highly unusual. And then, in the 5-4 decision, Justice Kennedy said, we find that there is no reality for money corrupting in politics or even the appearance of corruption. Now, if you want to find congressional experts on something, it's raising money and knowing what campaign contributions mean. And during the confirmation hearings of Roberts and Alito, stare decisis is rock bad. Sometimes changes when circumstances change, but that's what judicial restraint is and gives the public confidence in what is going on. And in Citizens United, the Supreme Court reversed 2 relatively recent cases, Austin and McConnell versus the Federal Election Commission. And as the dissent by Stevens pointed out, the McConnell versus FEC was the basis for legislating. So Congress looks at the Supreme Court opinion, comes back, passes McCain-Feingold, 100,000 pages, and strong statements by Roberts and Alito that it's up to Congress to find the facts because we have the hearings and we are out there raising money. We do know what that subject is all about. And 100 years of corporations can't engage in political advertising out the window. That's really restraint, ladies and gentlemen.
If I remember the Bourne case, let me just see if I remember some of my case law a little bit. That was a 7-2 decision for congruence and proportionality, 7-2, I think, including Justice O'Connor. And I think that there's at least some thought could be given to that case being an example of restraint, because the court, and again, I work in the weeds. I don't work at the high level, but I think that the Supreme Court could have decided under the Commerce Clause or under the 5th paragraph of the 14th Amendment, and they went on the lesser avenue and left to the Congress the authority to use the Commerce Clause. I think that's the way that case went. So you could argue that there was still a little bit of judicial restraint going on, a little bit.
Dean Fitz, you be the deciding voice here.
Well, I'm glad you told us what you thought of these cases. Let me step back and, in a sense, stand between the two positions here, and in a sense try and reconcile them. On the one hand, when you think of the major issues that are being debated today, both in terms of foreign policy, getting people back to work, entitlement reform, you don't see those as issues that are all across the board going to be decided by the judicial branch, which goes back to Judge Pratter's point. It's the least dangerous branch. It only takes issues that are brought to it, decides cases or controversies, it can't enforce them. So it is not as significant an actor across the board in the decisions that at least are in public debate today. Having said that, when they do take cases, as Senator Specter talked about, they have broad discretion about what they're going to do. And we've seen that in a number of cases, and we can argue about whether or not they came out the right way or the wrong way. But to some extent, they are largely unconstrained given both the broad strictures of the Constitution and their background. Now, having said that, I do want to take out a separate category of cases where the court deals with a set of issues where the political branches are somewhat in equipoise, not as a counter-majoritarian, but you can see the political branches facing off. And the court has had major influence in those contexts. Bush v. Gore, when in effect they were able to choose the winner of the presidential election, and then the healthcare mandate case. That's a situation where the political branches are, and the political parties are facing off against one another, and the court could intervene if it decides to fundamentally strike down a piece of legislation, which it would have a major impact on our society. So it's in contexts like that, it does seem to me that the Supreme Court could rightly be charged with being very interventionist and activist.
All these issues, of course, are being considered at the White House, and we have our first law professor president in some time, maybe since William Howard Taft or one of the others, but somebody who clearly has thought about these issues, and somebody, President Obama, who as candidate Obama ran as somebody who was at least somewhat of a critic of executive power, particularly during the Bush administration. It seems, though, once he took the reins of power, he, in many ways, continued many of the Bush policies, whether it was on anti-terror policies, Guantanamo Bay, even the Libya situation, not invoking the War Powers Resolution. Is this the kind of thing, this kind of broad expansion of executive power that we can expect from all future presidents, or can we expect it to be reined in one degree or another?
You're looking at me?
Sure. Take a pass on.
No, well, yes, I'm going to pass on the particulars, except to point out that I say that Senator Specter is absolutely right. People change their views when the circumstances change. I mean, that's happened from time immemorial. So Senator Specter is totally right. People change.
Why don't I, just to jump in.
And some people change when there's no reason to change. When the stare decisis was just handed down, there hasn't been any change in
Senator, I'm
circumstances
trying to
that
be
say-
your friend.
This
is this outreach thing I'm talking about.
I'm speaking, Judge. We're not in your court. We're not in your courtroom right now. I keep asking, what votes do I regret? I may choose one, named Pratter, if I'm interrupted too often.
Lifetime tenure, too late. Just wanted to.
Oh, well, okay. I thought the senator, but
Executive power.
It is certainly the case that whatever party is inhabiting the presidency, they tend to have strong views about presidential powers. And if you go back, you know, I'm taking a shorter snapshot, but President Reagan was probably of modern president, obviously President Nixon, but President Reagan of sort of the modern presidents was known as for asserting a strong view of presidential powers, power over the bureaucracy, signing statements, things of that nature. When President Clinton became president, he indeed, in the end, adopted many of his views about presidential powers. He had an aide at the time, counselor, by the name of Elena Kagan, who was advising him and who later left and wrote a very well-known article in Harvard Law Review in which she, in a sense, adopted many of the presidential powers views of then President Reagan. Obviously, the President Bush had a series of strong positions. But if you now look at President Obama, issues in terms of signing statements, powers over the bureaucracy, foreign affairs powers, in the case of Libya, he's been certainly taken the position that he should be able to assume authority, executive authority, like his predecessors. I can also point out recess appointments. He's been, I think, aggressive in pursuing recess appointments. I'd be interested what the senator's view is, who's seen this from all sides.
You've seen a lot of presidents come and go. Is executive power here to stay?
It's here to continue to be expanded. Institutionally, the three branches two of the three branches, in my opinion, and I'll be very specific as to why I think this, expand their power. If the Constitution were rewritten today, I think the judiciary would be Article 1. Now, they have the most power. They decide all the cutting-edge questions of the day. Bush versus Gore is an example. They elected a president by one vote. They decide who's going to live on a woman's right to choose. They decide who's going to die on the death penalty cases. They decide medicinal marijuana. They decide Guantanamo. And they also decide what not to decide. And the Congress is relatively inert because the Congress is constantly raising money and running for re-election. It is just a constant not paying attention to business. And the executive branch can act unilaterally and can expand power and get away with it. And I'll be specific. The terrorist surveillance program was warrantless wiretaps, and the Congress had legislated under the Foreign Intelligence Surveillance Act in 1978 in response to the things the CIA was doing, that the exclusive way to get a wiretap is to go to a judge, go to Judge Pratter and show you got probable cause, and she's going to be the judge, not going to be the FBI agent who's going to decide that. Federal District Court in Detroit says it's unconstitutional. The Sixth Circuit ducks it on standing, one of the principal ducky issues. Dissent, much more powerful than the majority, goes to the U.S. Supreme Court. They decide not to hear it. It's not generally understood, but Congress has the authority to tell the court what cases to hear. We can tell them, like McCain-Feingold was in the statute, you have to hear it. We can tell them. Can't tell them how to decide it, obviously. We can tell them what to hear. I tried to get that bill passed. No interest at all in challenging the executive branch. Take the signing statements. You all know the Constitution. Both houses present a bill to the president signs it or vetoes it. Well, that's not so. The president issues a signing statement. He cherry picks. He says what he's going to pass and what he's not going to pass, what he's going to enforce and what he's not going to enforce. And it goes on and on.
Do you think that the president does not have the authority to refuse to enforce what the president believes is an unconstitutional law?
I believe that if he ran out the string, Dean Fitz, that he'd have a strong case there. But if he sees something in a bill that he thinks is unconstitutional, I think he ought to veto it.
You think he's...
And he ought to say, I'm vetoing it because you've got an unconstitutional provision here. And then it goes back to the Congress. And we have a chance to say, well, we think you're wrong, or we'll accommodate to it. And then I think if he challenges the constitutionality on a conflict between the Congress and the president, the Supreme Court ought to decide it. That's what the Supreme Court is there for. They have a caseload of about 70 cases. They do hardly anything except go to conferences and be on panels. Compared to what they had in the past, Judge Pratter is frowning. But take a look at the statistics. It's just a nosedive.
Well, let's see if our audience agrees. I'd love to open it up to audience questions. I believe we have a couple of mics.
We all know or read about the basic paralysis that the United States Senate has been operating under, particularly in the last several years, because of the requirement of a supermajority, i.e. 60 votes, and the mere threat of a filibuster by the 40 votes, the ones that don't want something to get through, and that the country really is being governed in many ways by a 40-vote majority in the United States Senate. Now, I know that it often depends on whose ox is being gored as to whether or not that's a good or a bad situation. But my question is whether you believe that that condition exists raises a serious justiciable issue of constitutional import.
Oh, that's really for Judge Pratter, that's not.
No.
Why not?
You don't believe that the Supreme Court would recognize a challenge to the constitutionality of an internal rule of the Senate in that regard?
Well, you're my dean, but I agree with you on the merits.
Judge Pratt, I just want to add on to we hear no matter which president is, no matter which Supreme Court Chief Justice is in about the empty seats on the federal bench, the vacancy crisis. Is there a concern that these rules in the Senate are affecting that? It's not really a partisan issue, that it's just a matter of simple jurisprudence and being able to process the law. Is this a concern among your colleagues and yourself on the bench?
Yes. We think that the American people deserve a full complement on the bench. But what you want is to make sure that you've got more than just numbers. I think that we all want a bench, and we want lawmakers, and we want executive operatives who know what it is to do the people's business. So that if it takes a little bit longer to get the right people in, then I can't say that there's harm to that. The question is, do the candidates or the potential nominees just become the punching bag for a different agenda item? And that, I think, is much more off-putting and much more dangerous if candidate X it just becomes the focal point for others acting out their frustrations. So I think that that's the thing to worry about. The vacancies will be taken care of eventually, and until they are, the rest of us just do more work. Our court in the Eastern District of Pennsylvania has been carrying the load of an entire judgeship for the state of Delaware for a number of years. And Delaware hasn't been lost. I mean, their cases still get decided. So we make do. The judiciary is making do with less every year, but that's true for everybody. So yes, the vacancies are something to be worried about, but what you want are quality people who have made it through the evaluative process, who have answered the questions forthrightly, and who want to be the servant of the people to decide the cases. It's a great job. It's a wonderful honor, and I don't know anybody who voted Democrat or Republican or Independent who, when they become nominated and when they're sworn in, they don't just say it's an honor. They don't say it's a particular partisan honor. They say it's an honor to serve.
Next question, please.
Hi. Hi, my name is Ben Dworkin. I'm originally from Philadelphia, and I went to Penn undergrad. And my question is about the election of judges in Pennsylvania. Unlike other states, most judges, including the state Supreme Court, are elected. And I find that very disturbing that a sitting judge would have to campaign while he's sitting. Him or her would have to campaign and raise money for their re-election. Why is Pennsylvania different than most other states, and is there any prospect that will change?
Who would like to take that?
I don't think, there are very few people who've looked at that from an independent perspective who don't think that the system of elected judges in Pennsylvania is a good one. That is, it causes all the problems that you suggest, and I think that the state of Pennsylvania and the judiciary of Pennsylvania would be much better from all perspectives if they were not elected judges.
I agree with what Dean Fitz has said, but to change the electoral system in Pennsylvania, for example, you have to have a constitutional amendment. And the political leaders like to elect judges, gives them more power. And they're very influential in the political process. You had the celebrated case fairly recently in West Virginia, the Massey Coal Company case, where the Chief Justice got $3 million contribution, identifiable, and was the decisive vote in the 3-2 decision, invalidating a $50 million award against Massey Coal, the contributor. And Supreme Court 5-4 said that was wrong. But the business of electing judges is not a good idea.
Let me just to
I think,
put a little background here. One of the great debates, obviously, is issues of the independence of the judiciary versus the responsiveness of the judiciary to at least general views of the society. And the process of confirmation at the federal level, in a sense, identifies that tension. What questions can we ask nominees? What's the process of deciding who can be confirmed? But I think everyone agrees that judicial independence and a certain ability to step back, look at the long term of society, look at the litigants from a relatively neutral position is paramount to the quality of the judiciary. And a system of elected judiciary where members are raising funds and securing political support over the long run doesn't further our respect for the judiciary or the quality of the decision.
when I moved to Pennsylvania from California, there were two things that I found to be astonishing. One was the fact that judges were elected, and the other was the state store system.
Are they related?
I was going to say they are related at least in one way, and that is the difficulty of dislodging either.
Next question, please. In the back there.
Hi, my name is Laurie Hughes, and I work for the Faith and Politics Institute on the Hill, and we do bipartisan outreach. My question dates back to, I'm affiliated with Jim Wright. I won a scholarship in his name. I'm a political scientist from American University. And Jim Wright talks to me about how back in the day, in the 80s, he worked with Tip O'Neill, Ron Reagan. They used to go out and talk and have, civil conversations. And part of what we do at Faith and Politics is bring people together to have these conversations. Hoyer Blunt, people who are in office now. How can we encourage organizations like mine and other groups? I mean, how can we facilitate real dialogue? And I come from Democratic campaigns. It's not just partisan, because campaigns, it's all about fundraising. It's all about, winning. How can we just encourage more of real dialogue like they had back in the 80s and maybe the early 90s and not the system we've got now? So.
Senator Specter?
Well, the best way that I know how to get that real dialogue is the old-fashioned town meetings, where you go to the county seat and it's advertised in the newspaper, and you give a short speech and you answer questions. And the only way to get that done is for voters to have enough interest to vote out the officials who refuse to do that.
I think you've got to look at this from a lot of different vantage points. First, the political incentives for election and fundraising place, I assume, most politicians under pressures that they may not have faced 20 or 30 years ago, and that undermines this dynamic. It undermines the ability for people to come together. The media glare identifies any attempt to compromise, any attempt to move toward an agreement where fundamentally you're going to be viewed as abandoning your principles. So I think there are social and political factors external to what's going on in Washington that complicate this process. Years ago, there were context in which some ability to move people together was created with the Social Security Commission in the 80s, where, in a sense, people came together from both sides of the aisle without the spotlight. Whether that can be recreated now is, I think, a serious question. But I think you do need to look at political reform at the party level and media reform, as well as the structural reform about what goes on in Congress.
Just following up that, what would media reform look like?
It's okay, it's all right. Take a deep breath.
Right.
Well, I mean, we could get into questions of fairness doctrine and so on, but we clearly have lost sort of the centrist media. That is, the media now splinters into different categories, and they, with cable news and so on. So there are fewer contexts in which it seems to me the media played the same role as the big tent political parties, where they were committed to bringing people together as an institution. That's not how you get good ratings now, and that's not how you identify your subcategory. That's not true of Politico.
No.
I mean,
But isn't it healthy to have that kind of diversity, that broad array of opinions, where no one news organization is paramount, is the voice of God, as they might say?
the Walter Cronkite.
Right, and it's up to the individual citizen to take an array of news sources and draw their own conclusions from that.
But the examples that people see on television every night, or when they drive or they see it each other, finds its way into daily life in the courtrooms. I hate to keep waxing eloquent about my little world at 6th and Market in Philadelphia, but to hear what people say to each other. I mean, you all know what you witness walking down the street, and you hear what people say to each other, and you hear what family members say to each other, and the vitriol. I got a little bit of notoriety recently by ordering 2 lawyers to go have lunch with each other because of the names they were calling each other at a deposition. It was horrifying. So it's not just our politicians. I don't know whether it trickles down or it bubbles up, but I do know it stinks.
The difficulty is in having the people take enough interest to demand that kind of dialogue. But right now, I think the networks taking extreme positions is fine. Let them do whatever they want to do. It's a free society. That's really where the First Amendment works. Let them go ahead and do it. But the center is indifferent in our society. You have the parties controlled by the fringes. A super senator like Joe Lieberman can't win a Democratic primary. He was able to be elected as an independent because Connecticut allows that. Other states don't. A senator like Bob Bennett wasn't conservative enough for Utah Democrats. He only had a 93% conservative rating. And he voted for the bailout. In the fall of 2008, when the House of Representatives turned down the bailout, the stock market dropped to 700 points. And Vice President Cheney, that wild-eyed liberal, came to the Senate Republican caucus. I can speak about both caucuses. I'm about the only one who can. And said, if you don't pass this bill, you're going to turn George Bush into a modern Herbert Hoover. And Bob Bennett voted for it, and he was tossed out of office because of it. And you have Mike Castle losing to someone in Delaware who has to identify herself as not being a witch. And the Tea Party dominates it, and the fringes, so that if you want to get civil dialogue, civil people, the center has to participate.
Next question.
Hi, my name's Jenna Griswold, and I'm a recent graduate of the law school. So I'm going to ask a question about constitutional interpretation, if that's okay. Now, at the beginning, Dean Fitz and Senator, you both made assertions about the Constitution that I think all of us would agree with. First, Dean Fitz, you said that as originally planned, the different institutions of the government were basically designed to be inefficient. So it takes a long time to get policy passed. And then, Senator, you stated that there was a lot of compromise right from the beginning. We needed compromise to even have the House and the Senate. Now, I guess my question goes to whether we have a case of changed circumstances. Now we have such global markets that something that happens in Europe or Asia can affect us right here. And America really is hurting, and there might need to be quick decisions to alleviate some of the economic distress that might have even happened last week if the Greek decision would have continued, if it would have went to recall. So I'm wondering, given the globalness of our markets, how does that change how we view our constitutional system?
And Judge, feel free to jump in as well.
Oh, no,
You had a great legal education, by the way. It's a great question. I would say that's the $64,000 question. I don't know, given inflation in the market, whether that's the $30,000 question or the $100,000 question. But clearly, we have a legal system which was intended to facilitate and support dialogue, debate, and in some sense, inaction unless there was a broad consensus. You overlay on top of that a politically divided atmosphere where the checks and balances don't lead to compromise, but lead to a standoff, and an environment where you need to act. And you're pointing out, obviously, on a global level, the need to intervene and take action can be instantaneous. And that obviously is the critical question. My guess is that in crises or after sort of transformative elections, which 2008 could be viewed in that way, you do see the ability of branches to come together. In this environment, you do not. That is the sort of the criticism of our current system of government, that in those circumstances it leads to stalemate. I will say that is one of the arguments that is made on behalf of stronger presidential powers. That is certainly the argument that was made by I think supporters of President Obama's intervention in Libya, and in other contexts that, in a sense, the president needs to act quickly on an international sphere.
Well, picking up on what Dean Fitz says, the president does act, and he can. When we faced 9/11, we had an emergency and the Congress acted. It happened on a Tuesday, and by Friday we passed a resolution authorizing the use of force. We had a situation in Iraq in 2002, and we debated it, authorized the use of force. It was a bad decision because we were misled by our intelligence agencies and by our executive branch about weapons of mass destruction in the hands of Saddam Hussein. But we did come together and we acted. So that if things get bad enough, even a dysfunctional Congress can act, as the Congress did on
Crises.
on Frankel. If it's awful, something gets done.
Ms. Griswold, I think it may depend on what it is that needs to be decided as to how speedily we would hope it could be decided, or conversely, how slowly we might hope it should be decided. I can't help but recall that going back to 9/11 and the Patriot Act, things happened very quickly. Then there was more thought being put to those issues, and some rethinking and tinkering goes on. so that I suppose we all ought to be glad when it works, and even if it's terrible, we can act quickly, but let's hope that doesn't happen all that often. But my reaction to your question, which I think is a very stimulating one, is to say it really depends on what it is we need to do to know whether we need to act really quickly.
Back there, please.
My name is Georgina Yeomans. I'm with the Civil Rights Division at DOJ and actually a current applicant to Penn Law. I wanted to go back to what Dean Fitz was saying about the importance of judicial independence and the whole discussion about judicial activism. And I'm hoping the panelists might comment on the issue of recusal that has become somewhat in the spotlight with the impending review of the healthcare legislation and Justice Thomas's connection with the Tea Party.
Well, two panelists could perhaps address that. Let's broaden it out, actually, to the healthcare law, which I think we would all agree is likely to end up in the Supreme Court, probably in the hands of one justice, Anthony Kennedy. I don't want to ask anybody to make predictions, but any observations on how that process has worked so far, and what some of the final issues might be that the Supreme Court decides if and when it gets to that point, to that level?
Well, I think it's regrettable that the conventional wisdom is that it's going to be an ideological battle. I think it is a very sad commentary on the Supreme Court of the United States. And I don't know that Justice Kennedy is in play. If I had a guess, I would guess he's with Scalia and Alito and that side. And a lot of very, very difficult legal issues, and you'd like to have a feeling that you're going before a court which has an open mind and no agenda and no ideology, and will really wrestle with the issue of the Commerce Clause and the needs of the nation and the traditional balancing that the courts should come to. But I don't think you have it.
I just want to, did I hear you predicting that you think they will strike it down?
No, I'm not going to make any predictions. I'm just going to make some observations.
Dean Fitz, have you been surprised about any of the jurisprudence so far in the healthcare decision? We've had 5 or 6 district decisions at this point.
Well, let me say, the process of multiple challenges coming through multiple courts is a value of the legal system, in that you'll have different opinions across the United States reflecting on the problem, debating it over an extended period of time.
Well, let me ask you a question, Dean.
I've been called on it.
What difference does it make how many circuits have postulated how many different issues if 5 of the justices want to pick an issue like they did in Citizens United? They can pick the issue they want to decide.
Well, if the ultimate view is it doesn't matter, it's simply a vote, a 5-4, then you're absolutely right. I do think that I have a more optimistic view of the value of
You say
the
charitable view?
Optimistic. But I do believe this is an issue that has been advantaged by the multiple decisions. But it may be, in the end, you're absolutely right, that the court is going to decide this based on pre-existing ideological views.
May I just?
Please.
It should be of no surprise that I haven't had this case. I don't expect to have it. But I also want to point out that the data, and I don't want to overemphasize the use of empirical data for trying to understand what goes on in courts, but over time there's a fair amount of study and effort devoted to trying to dope out where the judges come to their decisions, and is it political or ideological. No one study, by the way, should be looked at for this, in my view. But if you look at all of the studies in a period of time, and you try and say, can you predict the outcome of a case on the basis of the political party of the president who nominated the federal judge or judges at issue, it is very difficult to actually put any money down and win on that bet. And I'll say that one of the reasons I say that is that there was a group of studies that were put together, and the upshot was that all judges reach a, quote, liberal decision about 42% of the time, and all judges reach a so-called conservative decision about 48% of the time. Now, what can you make of that? And that, I'm talking again about the trench work. I'm not talking about the 9 justices, for sure. They have their own issues about recusal. I have a law and I have canons that I must follow. Recusal issues are very tricky, by the way, and should not be tossed off as something that is simple. And I'll just pose this. What if you are in the District of Maine, where there are only a couple of judges, and you constantly are in the face of one of the judges to say you must recuse? That means his or her fellow judge has to take all of the cases. So recusal is not something that's a quick and dirty solution to something that just doesn't feel good. And at the Supreme Court level, far be it from me to opine on that.
I would just move to the Senator Specter side on this question, which is to say that who the president is who appointed a federal district judge and court of appeals judge probably matters less than many people think because of the nature of their docket, the nature of most of the issues they deal with. I don't think the same studies would suggest the same thing at the Supreme Court level.
I agree.
So I think it's a very different situation.
All right, I think we have time for one more relatively quick question, lightning round. Here, sir in the middle.
Brandon Paroli. I'm a 09 alum of Penn undergrad, and I should also reveal that I'm a applicant to Penn Law. But my question is primarily directed at Senator Specter, but anyone feel free to weigh in. You made a very eloquent case for why politically you believe that Citizens United was a wrong decision, and sort of touched a little bit on your support of a bill in favor of revealing corporations behind advocacy campaigns. But we here tonight are discussing politics in a legal context. And so can you maybe discuss a legal case for why Citizens United was a wrong decision, and what you would advocate, what sort of jurisprudence you would advocate in its place, given the First Amendment problems with it?
Before I answer the question, I just want to thank Penn for setting this up, and thank all of you for coming, and congratulate you on the good questions which were asked, and just observe that this is what candidates ought to be put to. We ought to insist that candidates have to appear in a forum like this and answer questions. Citizens United, I think, was wrongly decided on constitutional doctrine, because a case in controversy is the case brought by the parties. And the issues presented to the court was not the issue they reached for. They restructured the matter to decide a specific question. Then you have the doctrine of stare decisis, which is very important on stability, reliability, what people come to know, and that is really the core of judicial restraint. When justices disagree with the prior decision but follow it. And there have been many justices who have voted against something matter comes up for reconsideration and said, well, I'm really against that decision, but it's been decided by the court, and I'm going to follow it. And Alito and Roberts were questioned in great detail on stare decisis, really in the context of Roe versus Wade. And they gave very, very strong assurances. Now, stare decisis is not immutable. If it doesn't work out, if circumstances have changed, Brown versus Board of Education, dealing with gay rights, et cetera, lots of changes where the values of the society change. But not on whether corporations can pay for political advertising. And then the other issue is who finds the facts, hearings, witnesses, 100,000-page record, 100-year precedent for corporations not advertising. And then it goes right to the core of common sense. Are excessive contributions a corrupting factor or the appearance of corruption? And read Kennedy versus Stevens, and read Stevens versus Roberts. And on traditional constitutional law principles, it's hands down, in my opinion.
All right. Well, I think that brings us to the conclusion of our evening. Thank you.
Can we thank Dave?
Thanks, Jim.
Can I just, on behalf of the University of Pennsylvania, thank Politico for organizing this, and David for moderating this, and also Judge and Professor Pratter, who actually teaches at the law school, and as well as the Honorable and Professor Specter, who also teaches at the law school.
Thank you and good night.